computer. Okay, we're recording. If you have to leave the webinar early, I totally understand. We will send the full recording to everyone who registered for the webinar. But as I was saying, I know this is a really stressful time. If you registered or you have employees that were registered and you weren't selected in the lottery, I know it's this year in particular, the chances of being selected were absolutely terrible, honestly. And of course, we didn't know what the chances would be before, before the registration, but we'll talk about what that process looks like, what it means if your status still says submitted. We'll talk all about that first before we get into alternative options. This webinar is for you all. I want it to be as helpful as possible. So I'm going to run through some options, we won't go faster than necessary, hopefully, but we're going to talk through some options. But to the extent that you have questions, please put them in the chat. I was saying a minute ago, I'll keep an eye on the chat. And I may say, oh, we're going to cover that in just a minute, or I may just not address it because I know we're going to cover it in a minute, but otherwise ask questions. I want this to be helpful, and I don't know what you don't know. So feel free to ask questions as we go along. Before we get into kind of the substance of alternatives to the H-1B visa, a couple of things that I want to cover. One is that what happened with the H-1B registration process this year. So as you know, and by the way, this webinar is designed for both employers and employees. So the information that I'm giving is applicable to everyone, regardless of what your particular situation is. And before I forget, this webinar is for educational purposes only. It's not legal advice, and I can't give legal advice in a webinar setting like this. We'll talk about ways to set a time for a consultation if you have specific questions or want to walk through your specific situation at the end of the webinar. But it is for educational purposes. And like I said, ask questions because this is for you all. So what happened with the registration process? As you probably know, the H-1B registration process opened March 1st. March 1st,
I'm good.
And closed March 17th. And so we could register cases, submit registrations anytime during that window. At the end, towards the end of the window, we actually finished our
I just bought one about a month ago.
Sorry, if you can mute yourself, and if you have questions, put them in the chat.
Okay.
But the registrations, I'm going to see if I can mute everyone here.
Okay. Okay, bye.
So we finished all registrations on March 15th, Wednesday. But towards the end of the registration period, so registration period ended March 17th. So on the 16th, people started saying that they weren't able to make the payment. So basically the system crashed, the payment system crashed, and people weren't able to register, which was, of course, incredibly stressful. Like I said, our office was finished. Fortunately, we didn't experience that. Thanks to our amazing team, we were able to get everything done. But for others, it was very stressful. So USCIS extended the registration through the following Monday, which would have been the 20th, March 20th. So they extended it through 5 p.m. March 20th. We started getting notifications of selections on last Saturday. We received the first ones by email. We received a couple more on Sunday. Monday, this past Monday, so like 2 days ago, USCIS announced that they have completed the first lottery the first round of selections, and they've selected enough to be able to fill the slots that are available. So when we planned this webinar, we didn't know if they would have even run the selections or not, but they have. So we don't know, USCIS has not indicated yet. I haven't seen anywhere the total number of registrations that they received. Last year, it was around 400,000, between 400 and 500,000 for, again, 85,000 slots. So that's 65,000 for regular registrations, and then an additional 20,000 for US master's degree holders. As soon as we know the number of registrations, we'll put that out on social media, just so that everyone's aware of the number of registrations, but I would not be surprised if it was closer to 600,000. I kind of anticipated that it would be higher. Others were saying, oh no, I think it's going to be less because of all the layoffs, especially in the technology industry, but that's just, you can see that the demand is definitely there. So that's what happened with selections. You will see if you look on, so only employers or attorneys can look on the USCIS website where selections are actually indicated, or rather where the registration process is completed. But if you're an employer and you look on the page, it will say for each person case that was registered, it will say either selected, denied. So it would be denied if it had, if there were duplicate registrations. It would say denial for payment, or it would say invalid payment if there was a payment issue. Hopefully that's not the case. We didn't have any for which those were the case, a denial or invalid payment. Or it will say submitted. If it says submitted, that means the case was properly submitted in the registration, but it was not selected in the first round of the lottery. It's possible that there will be another round of the lottery that happened in 2021, year before last, because USCIS didn't select enough originally to fill the 85,000 slot. So in other words, people were selected and registrations were selected and then they didn't file. Either they were laid off, let's say, they filed through multiple employers, which happens a lot. Individuals will file through multiple employers, which I don't like, but it happens. I understand why people do it. And so they only filed through, let's say, one employer, even though they were selected for multiple, or they just changed their minds. A lot of times a person who registers in the H-1B lottery will have other immigration options, similar to the ones we're talking about today. So anyway, in 2022, USCIS learned their lesson, it looks like, and selected an adequate amount. They have to guess, it's all a numbers game, basically. So we'll see if there's a round two, but right now, there's no way of knowing if they're going, and nobody knows, even USCIS. They'll have to wait until the end of the period that we have to file petitions, which ends June 30th, to see if they received enough to fill that 85,000 slot, that 85,000 number or not. If they did not, there would be a second round. Usually that happens in July, if it's going to happen, or they will let us know once they have determined that this past year happened, like I think in September, maybe, but they'll let us know that they have received enough petitions and that they're not going to do another lottery. And again, we'll put that on social media to let everyone know. So for right now, yes, it's possible that there would be an additional selection, an additional round, but I don't anticipate that that's going to be the case. I could be wrong. I would love to be wrong. That'd be great. All right, so if you can mute yourself if it's not already on mute, that would be helpful. And again, put questions in the chat and I'm happy to answer those as we go along. So looking at what we're going to cover here, we are going to cover step one, assess your current situation. What is your current or your employee's current situation? The second step we're going to look at is set your goal and look at your particular options. So think about what your goal actually is. Is it to stay in the United States temporarily? Do you want to stay here long term? Do you not know quite yet? Totally fine. And then step three is to work the plan. So step one, assessing your current situation. The first thing you have to look at, even maybe before you look at what your goal is to determine what is your current immigration situation. So the steps, the paths that are available, the alternatives to the H-1B are going to be based on what your or your employee's current immigration status is. Are you on F1 CPT? Are you on OPT, STEM OPT? Are you on J1? Are you a dependent spouse, maybe working on H4 or on L2, or are you not working at all? And maybe you're here, maybe on one of those classifications or a different dependent classification. It just depends. And then what timeline do you have to make a change? And by the way, if you're not sure, I'm not going to be able to go into a lot of detail. This is kind of a high level overview of what your options are after if you're not selected for the H-1B. We do have a video series on YouTube called Sumner School Business Immigration Basics that we began a couple of months ago, and it's videos that are about 2 to 5 minutes long in length, and they cover these topics like what is F1 CPT, what is OPT, what is STEM OPT, and we've gone through H-1Bs and we'll be moving on to different visa classifications. So if you need or want further information about those classifications, that's available on our YouTube site. Or if you can't fall asleep at night and you need something, my soothing voice to listen to, You can learn about immigration at the same time and have it sink into your brain. It's awesome. So other considerations are, what timeline do you have to make a change? So for example, if you are on F1, which is a student visa, and you're working on OPT, optional practical training, when does that optional practical training end? If it ends in a year, then obviously you have some time to think about next options, depending on when it's possible that you haven't even received the OPT yet. It hasn't even started. So maybe you can be entered again next year, and or begin look into other options, because we don't know that the statistics, the chances of being selected next year are going to be any better. But when does your OPT end, for example? Can you extend your current status? So for example, if you are, let's say you're working in H-1B1, which is different from H-1B, but it's a classification for citizens of Chile and Singapore. And sometimes people don't want to maintain that because they want to start the green card process, or there could be other reasons that they want to change, but it could be that you can continue working indefinitely on that particular status. Or if you're on OPT, which is again, optional practical training for foreign national students after they've graduated, is it possible for you to apply for STEM OPT? The STEM OPT option is, and again, we have a video on this, but it would give you another 2 years of working on OPT. And during that time, you can register again. There's no limit on the number of times you can register in the H-1B lottery, but you can register again in the H-1B lottery. You might be able to start the green card process. You could look into other, some of these other options that we're talking about. So it's thinking about how much time do you have, or it could be that you're overseas right now, that we have, within our practice, we have a good number of clients corporate clients who have hired employees either as employees, as W-2 traditional type employees, to the extent that working overseas is traditional, working remotely overseas is traditional, but that are either employees or contract workers who are working overseas. So it could be that for now, while you figure out the next steps, you're able to continue working overseas without interruption. And one thing that I want to make clear to everyone on this call is that the options that we're talking about obviously are probably not your first choice, right? Because otherwise you wouldn't have registered in the H-1B lottery. But there are other options. You may not like them. You may think, oh my gosh, Emily, this is ridiculous. Why are you telling me this? Or they may be kind of, second choice, not the best option available, but there's a pathway. Not always, but almost always, a lot of times there is another option, even though it's not something that you had thought about previously, or you hadn't, you think is maybe not the ideal option. There are a lot of times, not always, but a lot of times other options. So keep the hope, even though you might be thinking, Emily, this is so much work. Yes, it is, but you have to think about your goals and meeting those goals. And sometimes you have to step out of your comfort zone a little bit. So think about, what is your current immigration status? That's one consideration. And then what timeline do you have to make a change? Step 2, look at your options. Okay, so we've talked about what are your current immigration options, or what's your current immigration status, and then how much time do you have to actually make a change, if any. And then 2, look at your options. First, before you look at your options, think about what your long-term and short-term goals are. So what's your current goal? What's your long-term goal? And you may not know, you may be at a point in your life that you're not sure if you want to stay. I hope you all want to stay in the United States and eventually become citizens. But I realize that that's not the goal for everyone. So it may be that you decide, okay, I'm going to work on OPT for as long as I can. And then I'm going to maybe go back to school, or I'm going to go back to my home country and bring my amazing skills and talents there. That's not what I want for you, but I'm not planning your life, obviously. But that's fine. That's not a problem to go back to your home country. And you may not know. You may say, all right, right now I want to continue working in the United States, if that's at all possible. And then in another 6 months, 12 months, whatever it is, I'll maybe have a better idea of what my long-term plan is. And same thing for employers. It may be that you have just hired this person on OPT, and it's actually a good thing that you have the opportunity, for you and for the employee, to make sure it's a good fit professionally, that they're a good long-term fit, and then to take the next step in a number of months, whatever that step might be. So the options, kind of bottom line, the options that you have are to stay possibly, the possible options are to stay in the US and work. And this is kind of how I've organized the options. To stay in the United States and work, that's probably your ideal scenario if you've been registered or have registered someone for the H-1B lottery. Option 2 is to stay in the US and not work. Not ideal, obviously, for lots of reasons, or to work, but not necessarily in the United States. The other thing to keep in mind is just because you go with one option right now, like for example, you might go back to school and start a new degree program, that doesn't mean that that's going to be the solution for the next, indefinite period in your life. It may be that you have to go, we have a client now, several, who have gone back to school to be able to stay in the United States, but they also have their employment-based green card process going on, and soon enough, they will be able to stop going to school. So it may be that there's an interim kind of stopgap measure that you have to take that's not your ideal situation, but it's going to get you where you ultimately want to be. So like I said, we've organized the options kind of around these three main things: stay in the US and work, stay in the US and not work, and work but not necessarily in the US. So staying in the US and working, there are two major buckets for this, right? So the first is non-immigrant visa classifications. That refers to temporary visa classifications. Non-immigrant visa means temporary visa classifications for almost every letter of the alphabet. So again, I said a minute ago that this is high level, and it is very high level. For almost every letter of the alphabet, there is a different visa classification, and there are subclassifications within those. So we're going to talk about the ones that are most commonly used, that are possible, likely possibilities or most likely to be possibilities. We're not going to talk about the diplomatic visas, for example, but there are, just know that there are lots of options and lots of things to explore. So I said there are two buckets. There's non-immigrant visa, and then there's the immigrant visa or the green card process. So we'll start with the non-immigrant visa, STEM OPT. That goes to what I said a minute ago, that you have to look at where you are, what your current status is right now. So if you are in OPT, optional practical training right now, you want to look at how long do you have left in OPT? And is it feasible to, during that time frame, what are your goals during that time frame? Do you want to continue to work? And obviously, probably, hopefully you do want to continue to work, but is it possible to start the green card process during that timeline and maybe get you to the point where you would be able to just go straight to the green card process, and we'll talk about that in a minute, and not have to necessarily leave the country? Are you eligible for STEM OPT? Not everyone, obviously, is eligible for STEM OPT. It is for individuals who have majored in science, technology, engineering, or math, and there's a very specific list of fields of study. So if you're not sure if you would be eligible for STEM OPT, you can check with your DSO, the designated school official at your university, and they'll be able to tell you, to guide you on that, to refer you to the list of fields of study, which changes sometimes, so be sure to check that. But it's not logical or intuitive, rather. So we have some clients who are dentists, and their dental degree was not on the list, and they didn't qualify for STEM OPT. We have other clients who are veterinarians, and their particular field of study did not fall. It wasn't, on the list of codes. So make sure that you check. And that's also a good thing. I don't know if we have anyone on here who's planning proactively, or now has to be planning proactively because you weren't selected in the H-1B lottery. But if you go back to school, or if you are in school now and thinking of continuing, when you're picking your field of study, obviously you don't want to study something that you hate, but if you're going to major in a STEM type major anyway, it's worth having a conversation with the DSO to say, hey, if I pick this major versus that major, is it going to make me eligible for STEM OPT? Again, STEM OPT allows you to have another 24 months of OPT in addition to the first 12 months of OPT that you're eligible for. And like I said, depending on your country of birth, you may be able to transition directly from the STEM OPT to the green card. I don't want to make it sound easy or painless, but it is something that lots of our clients have done successfully. Look at what your current OPT duration is. Again, you may be able to submit a registration next year in the lottery, although I would not recommend hanging your hat on that. There's no harm in doing it. But as you can see, from this year's results, lottery results, it's not a shoo-in situation. Another temporary visa classification is the E2. So these next four classifications we're talking about, the E2, H-1B, 1TN, and E3, are based on treaties. So it's not going to be, these classifications are not available for everyone. For the E2, it's an investor visa, and E1 is for traders. I didn't mention that on the slide, but there's E1 and E2. It's based on treaty. The US has a treaty with various countries that allows for the E2 classification. It is for investors. So for example, if an individual wanted to start a company in the United States, it's possible to do that and to invest in a company, either in an existing company or to start a company in the United States. That may not, if your employer, you may be thinking, okay, like that's not helpful, but we do have corporate clients who qualify for the E2 because of the ownership of the company. So if a foreign national owns a company and holds E2 status, they can bring employees in E2 status. So it's not necessarily something that's going to work, but it's something to be aware of as a potential option. The other thing is it could be possible for a person to obtain E2 status and then contract out their services to a US employer. It wouldn't be an employment situation, it would be a contract situation, but that might be a possible solution as well. H-1B1 is for citizens of Chile and Singapore, and it's similar to the H-1B. There is, let me go back to the E2 for a minute. There's not a limit on the number of E2s available each year. There is a limit on the number of H-1B1s and E3s available, but it's rarely met, knock on wood. So the H-1B1 is similar to the H-1B classification. The process is a little bit different, but it's, again, for citizens of Chile and Singapore, not country of birth, but citizenship. The TN is similar in that it's treaty-based. It's for citizens of Mexico and Canada. The E3 is for citizens of Australia, and all of them have similar requirements to the H-1B and similar purposes, but different processes. The L1 or the L is for intra-company transferees. So if you have a situation where you have an overseas entity, you may consider sending, you meaning a company, you may consider sending an employee over there to work for a year to meet the L requirements. And then once they meet the L requirements, so they have to have worked in the overseas entity for at least 1 year out of the past 3 years, it's possible to transfer them to the US on an L, either as a worker with special knowledge, which is helpfully defined as a worker with special knowledge in the regulations. But anyway, L1B is for individuals with special knowledge, or L1A is for managers or executives. The O1 is for, I don't know if anybody's heard of the EB1A classification, which is for aliens of extraordinary ability and the green card process. We'll talk about that in just a minute. The O1 is the temporary classification that's analogous to the EB1A. So it's for foreign nationals of extraordinary ability. There's a set of criteria you have to meet, at least a certain number, at least 3 of those criteria. So it's not easy. It's not the go-to, like the H-1B is, because only people at the top of their field, in theory, qualify for it. But it's something that's potentially worth looking into, especially if you work in something, it's not limited to the sciences, but it's well suited towards the sciences or research type occupations. It can also be used in the arts. It can be used in all different fields. But again, you have to show that you're at the top of your field. So if you have, 1 publication, for example, in your field, that's probably not going to work. But the O1 might be worth looking into, depending on how, what your resume looks like. And that's something that we're happy to advise clients on. The R1 is for religious workers. So if you're going to be a minister at a religious organization, for example, that would be a possibility. The other thing that I wanted to mention is the concurrent H-1B, which is something that some clients have actually used before. And I'm just looking at the time. The concurrent H-1B is something that clients have been used before. And we have a video on this also on our Sumner School Immigration Basics, which is available on YouTube. So the concurrent H-1B means you can have 2 H-1Bs at the same time. So you can work part-time at one, full-time at the other, part-time at both, full-time at both, whatever it is that you work out. The reason I'm mentioning this is because there is something called a CAP exempt organization. CAP exempt organizations include universities, institutions of higher education, nonprofits that are affiliated or related to institutions of higher education, and nonprofit research organizations and government research organizations. So if you are fortunate enough to be able to get a job offer at one of these CAP exempt organizations, that's a solution in itself, for individuals. I know it's easier said than done to get a job offer from a university, but that is a possibility. But I've also had clients who have obtained a job offer at a CAP exempt organization, and then also have a job offer at a CAP subject organization, like an organization, an employer who registered in the H-1B lottery and wasn't selected. So the regulation allows you to work as long as you're working at the CAP exempt organization. You can also work on a concurrent H-1B for the CAP subject organization. So that could be a possibility. And I've had clients do that before while the green card process is going on, and it's been amazing. It's been a great solution. Like I said, easier said than done to get a job offer at an organization, a CAP exempt organization, but it is a possibility. We have had clients do it multiple times. Someone asked about F1 to J1. The J1 is it's also a temporary visa classification, and it is used to facilitate intracultural exchange. So it can be used for all different things, like the au pair classification, the nannies come, camp counselors in the summer, long-term and short-term research scholars at universities. It can be used for interns and trainees who are working at regular organizations. There are certain requirements for the interns and trainees in terms of like for trainee, it depends on which classification, but there are certain requirements in terms of the amount of experience you have to have, how recently you've graduated. The purpose is not really for work, so it's important to keep that in mind. It's really for training and for an internship organization. So it is a possibility. It's limited to 12 to 18 months, depending on the classification. And with the J, it's possible to become subject to the 2-year, what's called the 2-year home residency requirement, which it could add complications to your immigration life. It's not the end of the world. There are waivers available, or you could go home for 2 years. So a J is not always necessarily a go-to solution, but it is a possibility if you want to stay in the US and work. So transitioning to the second bucket of staying in the United States and working is, and this goes to the question that Shreyas that Avanti just asked, can your company start the green card process even though your H-1 was not selected in the lottery? Absolutely. So that is what we're talking about right now. So the challenge could be, and we'll talk about this in a minute, but the challenge could be how long you have to wait for a green card. But in general, absolutely, your company can start the green card process, and we've had numerous clients do that over the years, and it's been a great solution. The employment-based green card options are the EB-1A, so that is for aliens of extraordinary ability. EB-1A and the NIW can self-sponsor. Not everyone qualifies. So when we say aliens of extraordinary ability, we're talking about people at the very top of their field. So if you have, and again, similar to the O, there are certain regulatory criteria that you have to meet, but it may be a possibility for some of you. The national interest waiver is easier to have approved. So the EB-1A, for anyone who knows, again, this is high level. So if you're not sure what I'm talking about, don't worry about it. EB-1A falls into the employment-based EB-1 category, the top category. So the wait for the green card is likely going to be shorter than one of the other categories, depending on your country of birth. The national interest waiver is also something that you can file for yourself. You have to show that your work is in the national interest. So believe it or not everyone qualifies for that. And there are other things that you have to show as well. It's not as straightforward as just filing some paperwork, but it could be a possibility for you. The perm labor certification is something that an employer would file. There's also I didn't mention this here, but there's the EB-1B, which is for professors or researchers that an employer that falls into the EB-1 category. The perm labor certification is what most employers use for most employees. I think it's fair to make that blanket statement. And we have had many clients over the years start the the perm labor certification process for individuals not selected in the H-1B lottery. Again, it depends on your particular situation, your immigration situation. Just having filed a perm labor certification or started the process, or even having filed the I-140 petition, which is the second stage in the process, doesn't allow you to stay in the United States. It doesn't give you permission to stay in the US. So that's not going to be a short or maybe even medium-term solution, but it is a possibility, absolutely. Priority date considerations, this gets a little bit into the weeds, but a priority date is the date is set by the date that your labor certification or your I-140, if a labor certification is not required. So if you're filing in the EB-1A or NIW classifications, it's the date that those are filed. So the priority date is the date that your initial petition or application is filed. That date, combined with the employment-based category that you fall into and your country of birth, will determine how quickly a green card is available for you. When I say country of birth, it's country of birth, not country of citizenship. And it is something that is a little complicated. There's something called a visa bulletin that's published once a month by the Department of State. And it tells us, there's multiple charts. There's actually at least 4 different charts. But anyway, it tells us how quickly a green card might be available. In general, no country, there's 140,000 employment-based green cards available every year. And as you can imagine, those get used pretty quickly. No country can take more than 7% of the overall allocation of green cards. So there is a separate category for China, India, Mexico, and the Philippines, because traditionally those people born in those countries have taken more than 7% or would take more than 7% of the overall allocation. So the bottom line is, if you were born in one of those countries, but especially India right now, there's going to be a longer wait for a green card. If you were born in a different country, if you're born in France, Canada, Bangladesh, Pakistan, basically anywhere other than China or India, then it's likely that the wait for the green card is not as long, and it may be a good option. The employment-based green card process might be a good option for you if you were not selected for the H-1B lottery, again, depending on what your current immigration status is. For the timelines, again, that gets into the weeds a little bit in terms of the timelines of the green card, and it depends on what your underlying immigration status is. Just know that depending on the employment-based classification that you undertake, it could be at least, I would say realistically, probably 1.5 years from the time you start to the time you get to the point that you're permitted to stay in the United States, just based on the green card filing without having to maintain an underlying status. That's a blanket statement. There are exceptions to that, of course. It depends on your particular situation, but it's not like you just file for the green card and then boom, you can stay in the United States. But it is something that's worked before and can work again, depending on your situation. So stay and work in the United States. This is our last classification before we move on to the other less appealing options of staying and not working, or working and not staying. Marriage-based or the diversity visa lottery. I have had clients before who have not wanted, they're in a long-term relationship, but maybe they're married, maybe they're not married yet, but they're in a long-term relationship with US citizens or potentially green card holders, and they're going to get married anyway. They didn't want, I've had a couple of clients in the past who didn't want to necessarily rely on that to obtain their permanent residence. They wanted to kind of do it themselves, go through the H process, but that didn't work out. And so they have gone through the marriage-based process, and there's absolutely nothing wrong with that, as long as it's done for the right reasons. You know, it can't be immigration fraud, of course. It has to be because it's a valid relationship, but that could be a possibility. I've also had clients who get married sooner than they otherwise would have. And again, it's not fraud. You know, it's not something that they're doing just for immigration benefits. They would have gotten married anyway, but the timing might be a little bit different than if they had been selected in the H-1B lottery. The diversity visa lottery is also a possibility. You probably don't want to hear the word lottery maybe ever again after having gone through this process, but there is a separate lottery. It's called diversity visa lottery. It is open. Usually people register themselves, and it's for individuals. It's not something that employers register for a part of. But it opens in November of every year. The Department of State will publish a list of countries that are eligible for it. As the name implies, it is for countries from which we don't have as many foreign nationals emigrate, and the idea is to diversify I don't want to say the source, but the countries that foreign nationals in the United States come from. So that is a possibility as well. I want to check the questions before we move on to our next big category here. If my F1 course program not listed in the SIP code, but university have selected other SIP code, can we take STEM OPT? That's more of a question for your DSO. They will tell you whether or not you're eligible for STEM OPT, but the SIP code for your course of study has to be one that's listed. SIP stands for Curricular Instructional Program. I'm not saying zip like zip code for the Postal Service, SIP CIP. So that's something to check with your DSO on, but it does have to be listed on the official list of SIP codes. Day one CPT programs could be a good option after STEM OPT ends. CPT stands for Curricular Practical Training, and it is available for, again, we have a video on this on Sumner School Immigration Basics. Is a program designed to allow a student to participate in internships, externships, hands-on type programs that are required as part of their coursework. CPT is not designed to be a substitute for employment, for a work authorization, for an employment type immigration visa, or that's duplicative, that's repetitive, but anyway, it's not supposed to be, the purpose is not to be able to work full-time. There are programs that will allow you to work full-time. I would just caution you to make sure that you're working with you're attending a reputable university. There are universities out there that are known for day one CPT, meaning they will give, when I say day one CPT, that refers to universities or programs that will give a foreign national student CPT from the first day that they begin studying at that university. That could be okay, but there are very comprehensive regulations around CPT. And my experience as a practitioner, immigration practitioner, is that there are some universities who will take very loose interpretations, to say it nicely, of the regulations. And that can be a problem later when you apply for a change of status to H-1B, for example, or to any other temporary visa classification, or when you apply for a green card, USCIS can go back and question that and question whether you've actually been maintaining status and whether that was issued properly. So yes, it's a possibility, but again, or that you are working with a reputable university, and don't be afraid to ask questions about, hey, how does this, how are these regulations actually being applied? I know that might be outside the scope of your comfort, but just know that there is risk in doing something like day one CPT, depending on how it's applied. Can you move to another organization for profit after your approved I-140 nonprofit? I think that you might be talking about the H-1B. The I-140 is part of the I-140 is part of the employment-based green card process, and so nonprofit and for-profit doesn't apply really in that situation. If you're talking about the H-1B situation that I was mentioning a few minutes ago, then yes.
Are you in the middle of rush?
You cannot move from.
If you can add these two underlinements that we're missing from this job.
I'm sorry, if you all would mute yourselves, if you're not already muted, I would appreciate that.
The original, because they made a mistake. I caught this. They logged it in as a separate job, and the client didn't want it as a
for concurrent H-1B. You have to keep working for the nonprofit in order to keep working for the original.
So I'm gonna leave these two. They're just gonna need to be added.
Remember, it's not just any nonprofit. It has to meet the regulatory criteria. Namely be associated with a institution or organization of higher.
This original job is on hold, and just need to add those two when you have.
So we're gonna.
We need to update everything as not a discrepancy.
Hold on for just a minute.
Because they submitted the same.
We're gonna move on.
So it's just two. It shouldn't take
the next classification: stay in the U.S. and not work, which is not an ideal type situation. but it is a possibility. So stay in the US and not work. So you could continue on your current status. Whatever your current status is, you could continue on your current status. So if you potentially, depending on how much longer you have in that status and depending on whether you can extend that status. So for example, we've had lots of situations where a person is on F1, whether they're on OPT or CPT, whatever it is, and they've continued in that status. So we've had lots of clients over the years go back to school to be able to stay in the United States and then potentially get another OPT, another set of OPT, another OPT. In order to do that, you have to have a higher degree level. It can't, you just, if you received a master's degree, you can't get another master's degree at the same degree level and then get another 12 months of OPT. It has to be a higher degree level. But it is possible to do that. Maybe you do that and you have the employment-based green card process go on at the same time. Or you could change status. So for example, someone asked earlier, if you are on F1 and then change to J1, that's a possibility. Or if you are, you can change to any number of classifications from F1 or from any other classification. So there are possibilities to stay in the United States, but you may not be able to work. So not necessarily the ideal situation. Alternatively, it may be that you can continue to work, but maybe not in the United States. And again, I know that that's not the ideal situation, but it is possible to work, especially in this post-COVID world. I know remote work has become more widespread. So it is possible to work from outside the United States, even as an employee. The I-9 requirements, where you have to complete the form and show that you're work authorized in the United States, do not apply to an individual who's working overseas. So that might be a short-term or long-term situation. I know we have at least a handful of clients right now, and I think I mentioned this earlier, who are a client, when I say clients, I mean corporate clients who have foreign national contractors who are working overseas, and we've started the green card process for them. We've also registered them in the H-1B lottery in the hope that they would be selected. But we have that green card process going on for them so that they can enter the United States at least within a couple of years, even though even if they're not selected for the H-1B. So like I said, that may be a long-term or short-term solution. And like I said a minute ago, just because you have one situation right now, just because you're working outside of the United States, or maybe you're staying in the United States, that is not your end picture. Just because that's what's happening right now does not mean that's how it's going to be forever. So step 3 is to work the plan. So the plan is depending on all of these considerations, all of these elements that we have talked about before. It depends on what your current immigration status is, if you're in the United States, how much time you have, and then what your options are. And that's something that we're able to help you with. But your plan could be to stay the course. It could be that you are on STEM OPT and you decide, all right, for right now, I'm going to stay the course, keep working on STEM OPT and register next year. Like I said, I wouldn't hang my hat on registering next year because I don't anticipate that the odds of being selected will be much better. But it could be, for any number of reasons, that that's what you decide to do. You decide to stay where you are for right now. You could have a consultation with us to put together a longer term plan. So again, I'm not able to give legal advice here. I wish I could just come up with a long-term plan for each one of you right now, but you could have a consultation to put together a longer term plan for yourself or for your employee. That might look like changing to another visa classification. So for example, maybe we look at the resume and find, oh, the O1 actually would be a viable solution for this particular person. Or it may be that you're in a situation where the J, I know I said before that there are limitations to it, and there are limitations to every classification, but I said that the trainee or internship may not be a great option, but maybe that is a good option for you right now, and will allow you to meet your goals. So having a consultation to put together a longer term plan. It may be that you don't know what your options are. It may be that this is obviously not your full-time job to advise people on immigration options or to do the research you look on Google, it's so confusing. It's not going to be helpful. But you might need a consultation to analyze your current situation in detail and talk about the different options, and then go back and talk to the employee that you have, or if you're an employee, to go talk to your employer and say, okay, these are the options. How do we want to proceed? What are our goals together? What are our individual goals? And what's the best option to proceed? And then it may be that you need a consultation to move forward with the alternative plan. So to actually execute your plan, it may be that, you know, yes, I absolutely want to proceed with the perm labor certification for this employee. They've been a long time, relatively long time employee, and we absolutely want to move forward with that, and not hang our hats on the H-1B in another year. So it may be that you know what you want to do, but you just need to execute it, and we're happy to help you with that as well. So what is the timeline for all of this? That's a common question that we get, and absolutely a great question. So the answer is, it depends. It depends on what it is that you're looking to do. If you are looking to file a change of status from your current status to a different status, you need to file the change of status before your current status ends, or before you stop being in that status. So for example, if you're F1 on a foreign national student, your status is duration of status, but you're not maintaining status if you're not going to school. So you would want to file that change of status before you stop whatever that activity is. If you are on H4, for example, you're going to have a specific end date. You're going to have an I-94 that has a specific end date. You have to file the change of status before that ends. The processing time for the change of status depends on, and I apologize, my dogs are barking in the background. I can't hear them. But it depends on the visa classification that you're seeking. That information is generally available on the USCIS website. If you Google USCIS processing times, it'll give you a general idea, but there are always outliers. And honestly, I don't find it overly helpful. The O1, if you wanted to change status to the O1, again, that's for foreign nationals of extraordinary ability, which may be a possibility for some individuals. That can be processed pretty quickly, even without premium processing. It can be done. The preparation process takes a while because there are lots of elements that you have to prepare, letters of recommendation, a letter from an outside organization, but it is processed once it's filed. It's processed pretty quickly by USCIS, so that might be a good option for you. The TN can be processed at the border if you're Canadian, so it can be a fairly fast process. Or if you're Mexican, you have to schedule an appointment at the consulate overseas. It's possible to do a change of status here in the United States. H-1B1 and E3 are usually done at the US consulate, so it depends on how quickly you can get an appointment there, although a change of status is also possible. The concurrent H-1B you can file for premium processing, so that could be for both of them, so that could be a possibility. The EB1 and NIW, similar to the O1, takes a while to process, to prepare rather, because there are lots of elements, lots of work that goes into that. So it can take a couple of months at least to process, to prepare all that. Once it's filed, it will probably take at least several months to be adjudicated by USCIS, although premium processing is available. That's when you pay an additional $2,500 to the US government, and they will make a decision within 15 calendar days for EB1 and 45 days for the NIW. The perm labor certification takes a longer amount of time. If anyone's going through it right now, you can attest to that. So it would probably be a year to a year and a half from the time we start the process to the time you're able to file. Okay, so it does take a while, but it's absolutely possible, especially if you're on STEM OPT, and not born in India, it's absolutely possible. We have, like I said, several clients going through that right now, and it's feasible. And we absolutely will help you walk through those timelines and look at some realistic timelines and come up with a solid plan. And then the marriage-based green card, if that's a possibility for you, again, it has to be for the right reasons, but if that's a possibility for you, that can be a great option. You can get your work permit usually within about 3 to 4 months, and you can get the green card possibly within 6 to 12 months. So that can be a great option. So recent or upcoming changes, and before we're getting kind of close to the end, and I have about 10 minutes. I have a 1 o'clock call that I've got to jump on, but if you have other questions, put them in the chat, and if we can get to them, we absolutely will. So recent and upcoming changes. If you are, some people ask, hey, I'm on H4, can I work? The answer is maybe. If your spouse who is on H-1B has an I-140 petition that has been approved, then you can apply for the H-4 EAD. Some good news there is that now USCIS is processing the H-4s and the H-4 EAD at the same time. So it used to be that they would process the H-4 and then months and months and months and months later, they would process the EAD, the H-4 EAD. They're processing them together. In addition, they will process, this is what they say, we have yet to see it, but I believe it, that they will process the H-4 and H-4 EAD with the H-1B. So if, let's say, the H-1B spouse files an H-1B extension or transfer or whatever it is, if you file the H-4 and H-4 EAD with it, they'll process everything together, even if it's in premium processing. That's something that they did pre-Trump, and they're reverting back to it, which is amazing. USCIS upcoming changes includes USCIS has a proposed fee increase out there. They have a regulation. Right now, the comment period has closed and they're going through the comments. They have to address all of the comments as part of the Administrative Procedures Act. I anticipate that that will come into effect later this year. So I anticipate USCIS fees will increase. And then another new thing that's already in place, which is also great, is premium processing is available for the national interest waiver. Like I said, it's 45 days instead of 15, but that's better than a year-ish that it might otherwise take them to process it. So some good changes that are coming up. So ways to stay updated. Read our blog posts. We post blog posts on our website. We have a newsletter that we send once a month, the first Wednesday of every month, that has links to videos, articles, blog posts that we publish, and then RSVP to future webinars. In addition, you can stay connected with us on social media. On Facebook, we have Instagram and LinkedIn. On my personal LinkedIn, Emily Sumner, I post regularly on immigration updates or changes that are coming, or just tips on immigration, immigration life, immigration processes. It's something that I love, and I enjoy sharing that information with other people. So stay connected with us that way. I have a few minutes left, so I'm happy to answer questions as much as I can here. Before we do that, if you have other questions, feel free to send us an email at info@sumnerimmigration.com. You can also send us an email if you would like to set up a time for a consultation, or you can go to our website and there's a link that says set consultation, and that will direct you on how to set a consultation. I'm happy to, like I said, I wish I could come up with a plan for everyone here, right now, but feel free to go to our website and we are happy to have a consultation with you and help you come up with a specific plan for your specific situation. There are options out there. Like I said, it may not be the one that you want or that you had envisioned, but there are alternative options out there. So going to questions, and keep the questions coming. I'll answer as many as I can. If the status shows submitted in the registration system, are candidates still eligible to be selected for the H-1B cap? So that's what I was saying a minute ago, is if an employer looks on the USCIS registration site, so the site where we submitted the registrations, it will say if your candidates may still say submitted. It's either going to say selected or submitted if you're one of our clients, or it could say denied or invalid payment. Hopefully it doesn't. But if it says submitted, that means that it was not selected in this round. It may be that there are going to be additional rounds. USCIS would not have selected enough petitions to fill that 85,000, because like I said, people may not file an H-1B even if they were selected. But it's not likely that there'll be additional rounds. It's possible. I would love to be wrong, but it will still say submitted until USCIS determines for sure that they have enough petitions to fill that 85,000 slot, the 85,000 slots. So it will probably still stay submitted through the end of this fiscal year, which ends in September. So it's okay if it says submitted. There's still hope, but it's not likely that that would change. Okay, on average, how long does it take to get a green card from the date that perm is returned from DOL as certified, meaning length of a process of getting travel authorization and EAD where priority date is current? Okay, that's a good option, a good question. How long does it take to get a green card? So this particular question is saying from the date that the perm is certified. assuming you can file the I-140 petition and the I-45 together, which is what this person has said, meaning the priority date is current and you're able to file the I-140 and the I-45 together. Once we submit the I-485 with the I-45, we submit the application for the work permit and the travel document. So that the work permit and the travel document should be processed within, the work permit should be processed within about 3 to 4 months. And the travel document should be processed within maybe a year. It's not great, the processing time for the travel document, unfortunately. But the work permit has been a lot better. It used to be they processed both of them together and it took close to a year to be processed, which is ridiculous. But now they are processing the EAD within about 3 to 4 months. It's not guaranteed. It could be longer than that, could be shorter than that, but you're looking at about 3 to 4 months. Another important note about that is that once you file the I-485, you are in what's called a period of stay authorized by the Attorney General. That means you have legal permission to be in the United States while it's pending. That doesn't mean you have status. It's a technicality. Status is if you are holding valid F1 status or H4 or H-1B or TN, any of those temporary visa classifications would be status. And like I said, it's a technicality, but you are permitted to remain in the United States while the I-45 is pending. So you don't have to keep maintaining your H-1B status or your F1, for example. How to expedite the H-4 if there's no premium processing option. So a couple of things. USCIS has said that they're going to open premium processing for H-4 EADs, hopefully this year. I will admit, I've been saying that for, I feel like 5 years now, a really long time. I feel like they've been saying that for a while. But I do believe that that's on the horizon. They've been opening up other premium processing for other things. So I think that that's coming. Hopefully this is the year that happens. But to expedite, you can submit an expedite request. The USCIS website has information, very specific information on the expedite request and the criteria for the expedite request. They say you have to meet one of those criteria, like economic hardship or government error, for example. There's a list of maybe 5 things. I will say it's not easy to have an expedite request approved. You would call USCIS. You can also, I think you can chat with Emma to make the request, but otherwise you would call USCIS. They could ask for documentation to back it up. We've had that experience before. So you could try it for sure. It's just that so many people want an expedite because USCIS is taking so long that it's possible that it wouldn't be approved, but it's worth trying, if you have a specific need, if you fall into one of those criteria. Does a person on an H-1B visa applying for permanent residency through marriage give up their H-1B once they've received their EAD? No, that's a great question. They do not. You can maintain H-1B status or whatever your underlying status is. So H-1B is dual intent, meaning you can pursue permanent residence and maintain H-1B status at the same time. So you could continue to extend your H-1B if you needed to. You could travel internationally using the H-1B visa if you needed to while you're going through the permanent residence process. But the bottom line, to answer your question, no, you don't give up your H-1B. You can keep that. And that's true even for visa classifications that are not dual intent. So the H-1B and the L are clearly, it's literally in black and white, dual intent. Other visa classifications like the F1, the TN, the E are not dual intent. There's not like guidance that says, yes, it's dual intent. But you can still, even though it's not dual intent, you can still keep working as long as your TN is valid or your E2 or whatever it is, you can still keep working pursuant to that, even though you're going through the marriage-based process. Personally, I generally recommend to clients that they maintain their underlying non-immigrant status, whatever that is, the H-1B or whatever it is, as long as they can until they receive their green card, just in case, heaven forbid, something goes wrong with the green card, which it shouldn't, it rarely does, but it sometimes does. And so when it does, it's nice to have that underlying status. But no, it's not automatically revoked or anything, even once you have the EAD through the marriage-based process. All right, we're at the top of the hour almost. We probably have like 30 seconds left. Thank you all so much for attending. Thank you for your questions. I appreciate you coming, and I hope that you'll join us for future webinars and contact us if you have questions. Thank you so much.